Brock, the president of Houston LERA. I'm on behalf of the board of directors of Houston LERA. I just want to welcome you to our second quarter program for 2023. Special thanks go to Chip Galagaza for our third vice president who championed and led this program. And we just have a great group of panelists today, so I think you'll really enjoy the discussion that they're having, and hopefully you'll have a lot of questions for them. Again, special thanks to Emily Smith and Bernadette Tiemann for their partnering with us and helping us with the technology. And Emily and Bernadette are with the National LERA organization and work very closely with us. So we're just most appreciative of their help. A couple of housekeeping items. If you have questions, put them in chat, and Chip is going to be monitoring those, and we'll ask those at the appropriate time or raise those, and maybe they will even do some raising of hands, but I'll let the presenters tell you what to do. And this program has been approved for 1.25 hours of Texas Attorney MCLEs and for 1.25 hours of SHRM Recertification credits. And later in the program, we'll put the information in chat on what you need to do to apply for those, be the course number and other information, instructions on how to do that. With that, I'm going to turn it over to Chip, and thanks again for participating in this program with us.
Thanks, Mickey. Welcome to everyone who's joining this program. As a labor law was always my first love as a lawyer, and I'm really excited that we're presenting a topic on traditional labor law. We're also privileged to have three superb presenters. I'm going to introduce them quickly. One is Tim Watson. Tim is the regional director of the NLRB Region 16. He's been with the board in various capacities since 1988, if I've got that right, Tim. He's a graduate of the University of Oklahoma College of Law. Go Sooners, my sister would say. And he's been now in the director's seat, the regional director's seat, since I think it's been, 2017. Tim is, for those of you on the management side, he's not totally the enemy. He's actually a nice guy, and you can talk to him, and he will reason with you, but he's not going to roll over for you either. We have a union representative, someone I've known as long as I've been practicing law, Pat Flynn. Pat, from day one, has been among the preeminent union side labor lawyers in this town, in this entire region. Pat, again, is someone who fights very hard for his clients, but I think fights fairly. It harkens me back. I know I'm old because I harken back to the good old days. It's the way I think law should be practiced. Pat and I share sort of a similar dissimilarity in our backgrounds. One thing I did not know about him is that his undergraduate degree is actually in management. And his father, what I did know about him, was a business owner. Pat then went to the other side. On the other hand, I'm from a long line of union card carrying FDR blue blood Democrats, union officers, the whole nine yards. I ended up going to work and working for a management side labor firm and have been on that side of the docket. Pat and I have done battle on several occasions, but again, it's been, we fight hard, but we fight, I think, fairly and honorably. Pat knows his stuff. Finally, we have a substitute. While John Harper was going to be the management side representative, those pesky clients sometimes in their matters have to take precedence. So substituting for John is Lance Bowling, who is a senior counsel at Littler. I've known Lance from work when he was in-house at ExxonMobil, and at my former firm, we did work for ExxonMobil. Lance's entire career has been spent as a labor lawyer. Again, he's had the good fortune, in my opinion, to be a labor lawyer, not have to mess too much with that pesky employment law stuff. Lance, again, is another lawyer who knows his stuff and will speak knowledgeably and articulately from the management perspective. So with that, I'm going to turn it over to Tim and step back. I will put the information you need for your credits in the chat box, and I will monitor the chat box for questions. With that, Tim.
Chip, thank you. Thanks, Mickey. Great to get to share the stage with Pat and Lance. And I would be remiss if I didn't also say what a great crowd we have here. Lots of familiar names, a few familiar faces, some former colleagues. I think if I'm reading the participant list correctly, former resident officer there in the Houston resident office, Nadine Littles, and I think I see a name of another former NLRB colleague, and very excited to see his name from NLRB headquarters, from NLRB Region 5. There can't be two Joe Banashevskis who are out there. So I just want to a shout out to Joe too, a former colleague. Really nice to see your name out there, and so great to be with everyone. I think we can officially say this is a great group based on what I just summarized, right? I'm gonna spend some time with you today talking about first NLRB Region 16. It's my home, so I have to start with the discussion about the region. I will do a really fast, I think a 3-minute basics discussion on NLRB / NLRA. It'll be real quick hitting. So those of you who know what I'm talking about already can nod, and those of you who don't wake up thinking about the NLRB every morning can make note and take note of some of the basic stuff that we talk about. And then we'll jump into the meat of the presentation. We're going to talk about some updates. We're going to talk about where we were, where we are, where we're going on independent contractors, and we're going to talk a little bit about General Counsel's position on captive audience meetings. We'll talk a little bit about electronic surveillance, again, looking at the NLRB General Counsel's position on electronic surveillance issues, some general discussion about NLRB remedies and some recent developments. A very recent case from right here in Texas, Region 16, a case called Lion Elastomers that looks at how employers might respond to employee outbursts or maybe inappropriate conduct by employees. And so we'll take a look at that case too, and then we'll kind of see where we are on the clock if we can get to some other hot topics. And as you heard already, there'll be time and an opportunity for questions, and we'll answer the questions you have if we can. So start with an intro to my region, Region 16. For those of you who don't know, Region 16 covers almost the entire state of Texas. We don't have those 3 counties far out west where El Paso is, but we do have one county in Arkansas where Texarkana is located. And we actually had an election this morning in Texarkana. So we do have business in Texarkana. We cover that vast territory with 3 offices, the regional office in Fort Worth, where I am coming from today. And then of course, resident offices in Houston and resident office in San Antonio. And since this is Houston LERA, let me just say a couple words about the Houston resident office. We have a field examiner there now, Alex Hernandez. He actually has been there for a number of years. The new staffing news is within the last year, we've hired 2 attorneys in the Houston resident office. Julie St. John is one of our new attorneys, and Joan Larson, also a new attorney in the Houston resident office. And those folks are very busy along with the rest of the staff in Region 16. And I just have to, I can't pass up the opportunity to just tell you about just briefly how extraordinary the last year plus has been in terms of the intake that we've seen at the National Labor Relations Board. So I'm going to talk fiscal year, and I'm going to talk numbers here for a few minutes. Last fiscal year, 2022, that ended last September, unfair labor practices nationally were up 19% across the country. And then for that same period, representation case filings, and this is again in fiscal 2022, were up 53% over the prior year. And so total case intake nationally up last year more than 23% over the prior year. So that's national. And we've seen even bigger increases in intake here in Region 16. Our unfair labor practice cases last year went up 32% from the prior year, and our representation cases went up 60% from the prior year. We had 963 unfair labor practice cases filed in Region 16 last year, and that was the most in more than a decade. So really pretty historic intake numbers. And then I just have to finish it by telling you that's continued this fiscal year, the year that started last October 1, additional increases in C cases, another 12%, in representation cases, another almost 30%. And that was as of the halfway mark in the fiscal year at the end of March. It hasn't slowed down since then. So if you have business before the board, just know that the board agents have extraordinary caseloads right now. Our trial docket is also pretty full too. So grace to be shown to board agents is appreciated. They're working hard, and they're working as fast as they can in what really is, pretty remarkable times. Okay, that's my intro to the region, and now my 3-minute NLRB basics discussion coming up, starting right now. So first of all, everyone knows NLRB, a independent executive branch agency. We enforce just one law. It's the National Labor Relations Act. That's the law that gives employees, workers in the United States, the right to form unions, join unions, support unions, to engage in activity to try to improve their working conditions, raise concerns about their hours, safety issues, even when there's no union involved. The NLRB is a bifurcated agency. We have presidential appointee board members. If fully constituted, there are 5 board members. They serve 5-year terms. We have 4 board members right now. We have a chairman, Chairman McFerrin. We have 2 other Democrats, so a total of 3 Democrats on the board right now. David Prouty, Gwen Wilcox, and then the lone Republican right now is Marvin Kaplan. The only thing of note there is that member Wilcox's term expires here in 3 months, so in August. So hopefully the NLRB gets a little congressional floor time this summer, and we can fill that vacant Republican slot and also get member Wilcox re-upped so that we'll have 5 board members going forward, hopefully. Other side of the agency is the General Counsel. General Counsel currently is Jennifer Abruzzo, also a presidential appointee. She serves a 4-year term. She's the agency's chief prosecutor. She's the one that decides what cases are going to be litigated. She oversees all the field offices, oversees investigations, and again is responsible for all field offices throughout the United States. Just wrapping up basics, 6-month statute of limitations. Everyone needs to know that. And then finally, everyone needs to know that the NLRB has really broad jurisdiction over just about all private sector employers and their employees in the United States. We don't have a jurisdictional requirement that you have to have a certain number of employees in order for the NLRB to assert jurisdiction. What is required is that an employer engages in some small amount of interstate commerce or some amount of gross revenue, and the standard is pretty low. So again, jurisdiction over just about all private sector employers. There are some notable statutory exclusions that we have to tick off. No jurisdiction over railroad or airline workers, no jurisdiction over employees of political subdivisions at any level, no jurisdiction over farm workers or agricultural workers who are actually in the field tilling the soil, no jurisdiction over domestic workers who are employed directly by families, no jurisdiction over supervisors, and those are individuals who have the authority to hire, fire, discipline. You can find the definition in the statute. Exercising independent judgment in undertaking those duties is required for an individual to be found to be a supervisor. And then finally, to segue into our first hot topic, there's a statutory exclusion for workers who are classified as independent contractors. Okay, so independent contractors not protected under the National Labor Relations Act. Hence, independent contractors don't have the right to, under the statute, under the NLRA, to form a union, to join a union, to support a union. They also don't have the right to engage in that other protected activity, even when no union is involved. So no collaborating with your fellows if you're an independent contractor about your pay, about safety, about other terms and conditions of employment. So that's easy. We can look at the statute and see that independent contractors are excluded. The hard part, though, is figuring out which workers are independent contractors versus statutory employees. And the beginning of trying to sort that out is going to the law and going to see what the board's current test is. And that current test can be found in a case called DFW Super Shuttle. It's a case from the board from 2019, and it is a case from right here in Region 16 and right here in the Dallas-Fort Worth area. And the board applied the common law test, looked at all the common law factors, extent of control, and all the other factors. And in that case, found that Super Shuttle drivers at DFW Airport, at Love Field in Dallas were not employees, were not entitled to unionize, were independent contractors. And that's the law of the land as it exists right now. It just so happens that in Super Shuttle, the board overturned two prior board decisions, both involving FedEx drivers. And so current law is an expansion of those workers who would be found, expansion beyond what the board had said in FedEx, for the workers who would be found to be independent contractors as opposed to employees. In the Super Shuttle case, then member Lauren McFerrin, now NLRB chairman Lauren McFerrin, filed a dissenting opinion. So right there, that gives you some sense of what might be happening, where we might be going with this independent contractor issue. And in fact, carrying it forward in a case called the Atlanta Opera. So if we have Super Shuttle drivers, and now we have the Atlanta Opera, where we're going to be looking at this independent contractor question. In that case, in December of 2021, the board invited the parties in the case, invited the public to submit briefs and to address the question of whether the board's Super Shuttle decision should be overturned. And if the board were to overturn its Super Shuttle decision, what test it should apply in place of Super Shuttle. Well, one of the parties in the case, General Counsel Jennifer Abruzzo, she filed a brief and she asked the board in this Atlanta Opera case to overturn Super Shuttle and to come up with a new test, a test that would be consistent with the statute, consistent with Supreme Court precedent, but at the same time would also, give workers the broadest possible protection. Again, consistent with the statute and Supreme Court precedent. So that's the first case of the day that I will tell you to be on the lookout for, the Atlanta Opera case. Now, before I hand the baton to Lance and Pat, I've got two more independent contractor matters just to kind of tie up this discussion that I wanted to mention. And the first one is related to the General Counsel's position on the employee status of student athletes, or what she calls players at academic institutions. She's taken the position that players at academic institutions are employees. They're entitled to protection under the statute. She said it in a GC memo GC Memo 2108. That's a guidance memo that you can find on the NLRB's website. Again, 2108. You can find it at nlrb.gov. She's also taken that position in a case involving University of Southern California, the Pac-12 conference, and the NCAA. So that's her position on student athletes and their status as employees. Final word about independent contractor is, what about misclassifying workers as independent contractors instead of employees? Current law can be found in a case called VLOX, also a 2019 case. The board in this VLOX case, and just if you're taking notes, it's volume 368, number 61. And it's, as I said, a 2019 case. So what did the board say in VLOX? Board said, hey, yeah, you know what? There could be some circumstances where misclassifying a worker as an independent contractor as opposed to an employee could be a ULP. If you did it in response to union activity or protected activity, like we're going to classify you because we heard that you're trying to form a union, or if you did it to prevent, kind of preempt or prohibit employees from engaging in protected activity, those could be ULPs. But at the end of the day, the board said, standing alone, if you don't have any of those other factors, just a standalone misclassification, which would deprive employees of statutory protection, that's not a ULP. That's what the board said in VLOX. General Counsel Abruzzo has a different opinion. She thinks VLOX was wrongly decided. She's taken the position in a number of cases that misclassification is a standalone unfair labor practice. And, you know, consistent with the position that she's taken there, one final thing you should know about her position is that the NLRB is collaborating with other federal agencies, with the Department of Justice Antitrust Division, with the Federal Trade Commission. And the goal of the collaboration, or one of the goals of the collaboration, is to reduce employee misclassification. And then there's one final goal, and this is another kind of keep your eye out for this collaborative work between the NLRB and the FTC, is that part of the collaborative effort is to give attention to matters related to non-disclosure, non-solicitation, non-compete agreements. And if those agreements, those clauses or provisions could violate employees' Section 7 rights, then that could be a matter that would come to the attention of the NLRB. And there are cases being filed alleging non-competes are unlawful. Okay, now I'm throwing it to, I guess, well, we could alternate. I'm going to throw it to Pat first about independent contractor and misclassification issues.
Okay, thanks very much, Tim, and greetings to everybody on the program here today. I don't have a whole lot to say about this, and I probably won't have a whole lot to say about anything. As you can tell, Tim is quite thorough, which we always enjoy. But just a couple of things. I'm glad to hear about the collaboration because, I was thinking in my mind as you were talking about this subject, and as it always comes up, there are so many different views on independent contractors. I mean, the IRS, they have a test. The Texas Workforce Commission has a test. The courts have a test that come up a lot with regard to the Fair Labor Standards Act. And then, of course, we have the board. So I'm glad to see there is some collaboration going on in that area. And I certainly support the General Counsel's view on that issue, with no offense to Region 16 on a super shuttle. But one question I have for you, Tim, is, the board has already issued a decision on the student athlete issue. And how does the General Counsel's current view compare with the board's decision that came out a little while ago on that student athlete issue?
Well, if you're talking about the Northwestern football player decision, I would just say that the board's decision in that case didn't really answer the final question. I mean, they declined to assert jurisdiction in that case and set forth a number of reasons why. I think that, the former General Counsel, General Counsel Griffin, took the position that student athletes, players at academic institutions were employees, and of course, General Counsel Abruzzo has taken that position. So I think that's where we are right now, kind of waiting for a case, and it might be the USC case, but some case to work its way to the board to where you would get a clear, definitive position from the board about those workers and their status.
Okay. All right. Thanks. I'll turn it over to Lance.
Yeah. So on independent contractor status, I mean, I understand its import, but I think probably the more important issue is whether or not employees who are employed by an independent contractor would be considered jointly employed by someone else. And that may be something else that you might be getting to here, Tim. But with the exception of your drivers who may own their own vehicle, things like that, where they're called upon to deliver a final product, I don't know that independent contractor moves the ball quite as much as joint employer. At least in my mind, what's keeping me up at night is probably independent contractor joint employer more than independent contractor. And I kind of wanted your thoughts on how those two really interrelate when it comes to the board's thought process.
Yeah. So where we are right now, with respect to joint employer is the determinations about joint employer status under the act right now are governed by a board rule. The board been around we're approaching 90 years, and for most of those decades, the board engaged in very little rulemaking. Almost all board law is via adjudication. That picked up, in recent years, and the prior board engaged in some rulemaking about joint employer, and that's what governs and what guides us right now. The current board is looking at rulemaking, and so I think it's hard to predict what might happen. One could predict that what you might see in a new board rule would look something like the board's decision from a few years ago in a case called Browning-Ferris. So that's just a possibility. But I think really what we have to do is we have to wait to see how this unfolds. And it's something that is going to unfold. It's going to unfold later this calendar year. And so that's a keep your eye out for and to be continued on what will ultimately happen with joint employer under the act.
Let me throw out a quick question to you, Tim. It's on another subject, but rulemaking. I have some clients, I think, in the audience who are in the construction industry. Is there anything on tap for them on that subject this year? My understanding that there could be.
Yeah, sorry. Yeah. I think that's right. I think there's other rulemaking that the board is looking at, and it's interesting. As I said, not historically something that the board has leaned on heavily, but there's an interest in engaging in rulemaking. I mean, I think that part of that is to avoid unnecessary litigation. I think that motivates the board to engage in rulemaking, to give practitioners some certainty about the law, maybe to try to avoid oscillation in the law. And again, I think that probably goes together with providing some certainty. So yeah, I think be on the lookout for rulemaking in some other areas too.
Do you know what's on tap as far as the construction industry consideration is?
No, I don't have that at hand, Pat.
Okay. Okay. Thank you.
Yeah. So we talked about whether we wanted to do, I guess we don't have any questions in the chat. So I think maybe we'll just, folks have questions about independent contractor, we can field it at the end. And I will, just because we have lots on the agenda here, I think I will jump into our next hot topic. And it's scorching hot. The question about the recent board decision involving severance agreements in a case called McLaren-McComb, and that is a case, and I'll give you the case site since we're not doing PowerPoint today. It's 372 NLRB number 58, and it's a case from February 21st, 2023. So just a little bit under two months ago. So brand new board decision. And I'm going to talk about that, but because we want to talk about how we got there, I want to tell you about another NLRB Region 16 case, another Texas case that until 2 months ago was the law of the land, and it's a case called Baylor University 369 NLRB number 43, a case from just 2020, so just a few years ago, and that case actually had been a departure from prior board law. But let's just talk about what the board said in Baylor. The board said in Baylor, when you're looking at severance agreements, circumstances matter. The underlying circumstances of how the severance agreement came about, how it was presented, matter. And the board said that it really does matter, because guess what? If you don't take into consideration the circumstances, just the mere proffering of a severance agreement does not violate the National Labor Relations Act. There's only going to be a violation if you find things like underlying animus or underlying other coercive or threatening conduct that accompanied the severance agreement. So under Baylor, mere proffering, not an unfair labor practice. That's Baylor. What happened then in the recent board decision in McLaren-McComb? Well, in McLaren-McComb, the severance agreement had some broad non-disparagement language, had confidentiality clauses, and the board looked at those provisions and concluded that those provisions were coercive, that they violated employees' Section 7 rights, and found a violation in that case, concluded, contrary to Baylor, that mere proffering was an unfair labor practice. And so the board in McLaren-McComb reversed or overturned the Baylor case, overturned another case called IGT at the same time. And so current law under McLaren-McComb, mere proffering is an unfair labor practice. Well, this case got lots and lots of attention, right? There was lots of media attention, mainstream media even. And so a month after the board's decision, the General Counsel, because of all this attention, because there were lots of questions about the meaning of the board's decision. And of course, ultimately, the board will have to sort that out, what they meant in their decision. But the General Counsel did provide practitioners and the public guidance her view. And I need to repeat that's just the prosecutor's view. That's not board law. That's not precedent. But the memo, which is GC Memo 2305, again, available on the website, nlrb.gov. So that's 2305, is a great resource for practitioners, and it is framed in the form of kind of questions and answers. And we don't have time for me to go through all of the matters that she addressed in her memo. Again, great resource. Do check it out. I will flag a couple of highlights for you. One is just kind of address the elephant in the room. The big question was and this was because this was reported in the media that the NLRB had banned severance agreements. Well, no, that's not true. The board made clear in the decision that now and for decades prior, board cases have said it's okay in severance agreements for an employer to ask employees to waive rights to pursue employment claims that arise as of the date of the agreement. That's okay to continue to do that. It's okay to continue to proffer, to maintain, to enforce severance agreements that have those kinds of provisions. So that's one thing I wanted to highlight. Another thing that got a lot of attention was trying to figure out, wow, wait a second, is this applied retroactively? Your clients are wondering about all these severance agreements that they have stacked up over in the corner that they have had employees sign, and are those in play? And so General Counsel talked about that. I think if you're looking at a severance agreement that was proffered, let's just say 2 years ago, well, we know the NLRB has a 6-month statute of limitations. So that proffer that's more than 6 months ago, that's probably going to be time barred. But if the agreement continues to be maintained, and if the agreement is enforced within the statutory time limit, then that's not going to be time barred. And just another word about retroactivity: all board cases are presumed to be applied retroactively. That's something to know. The board will address a question of whether the retroactive application would amount to a manifest injustice to the parties. And in the absence of the board determining that there would be manifest injustice, then retroactive application is in play. So that's another thing to know. And then just 2 other points. The guidance memo 2305 talked about, well, okay, in McLaren-McComb, there was a non-disparagement provision, there was a confidentiality provision. Are there other provisions in these agreements that we might want to be on the lookout for or be concerned about? And she said, yeah. You, as I've already mentioned, in this collaborative effort that the NLRB has with the FTC, you might want to be mindful about non-compete clauses, no solicitation clauses, no poaching clauses, or really broad liability releases and other kinds of covenants not to compete. So she identified those provisions as the kinds of provisions that may run afoul of employees' Section 7 rights. And then final word: what about savings clauses? Can we have a really great savings clause to save the day? And the answer is, maybe, maybe not. It depends. And I think that what she offers as guidance there is, go look at my brief, General Counsel Abruzzo's brief, that was filed in a case called Stericycle, Stericycle. It's a case out of our Philadelphia regional office. And in her brief in Stericycle, she kind of lays out like this model language that might be used. And so I commend everybody to check out the Stericycle case, and to keep their eye out for that case for a variety of other reasons too, including that's the case in which the board may revisit its decision in Boeing regarding employee handbooks. And I will leave that alone and not talk about that any further. And I think I'll throw it to Lance first this time.
Sure. So as you can imagine, at Littler, this generated a lot of conversation. We had lunch meetings about it. There was, a long email tree that existed for several weeks about this. And I think we're starting to feel comfortable where our guidance is on this. But a few things to highlight for the folks on the call that may be helpful in putting it into perspective is that this does not bear on every single severance agreement that's out there. It bears on severance agreements that companies enter into with employees as defined by the Act. So if you have a severance agreement with someone who is a vice president you can absolutely expect to be able to enforce confidentiality and non-disparagement provisions against someone like that because they're not employees under the Act. So I think that's an important thing to highlight. And also, just because sometimes people gloss over in generalities, oh, now we can't have confidentiality. This does not mean that you cannot have a severance agreement that defines what confidential information is and precludes employees from using that confidential information in the future. For example, trade secrets, other matters that are maintained confidentiality as kind of the secret sauce of a company. That is still fair game and is something that can and should be included in severance agreements.
Yeah.
Thank you. Just a few things. The decision is really a whole lot broader than just severance agreements. I think it'll impact just general employment contracts, at least if it's someone who's covered by the Act, as Lance pointed out, and also just general settlement agreements, settling grievances and lawsuits, those kinds of things, because these clauses that were touched on in the McLaren-McComb case, specifically confidentiality, non-disparagement, they're pretty standard fare in all of those types of documents. So you need to be careful about how they're worded. I was listening to a program yesterday, and the Deputy General Counsel, Peter Orr, was talking about this case, and he mentioned that, and it was ironic, the same day I got a settlement agreement of a grievance where there's a confidentiality clause, but it is limited to disclosing or not disclosing the amount of the settlement. And Deputy General Counsel Orr said yesterday, that's okay. So if people are concerned about that little portion of confidentiality, that's okay. And the employer lawyer sent me this grievance settlement agreement, and I said, well, I haven't read this yet, but I hope your confidentiality clause isn't too broad. And he wrote back, said, no, the only thing we're making confidential is the settlement amount. I said, okay, well, that's good. So that's something that's you need to know. And then with regard to the limitations issue, as Tim was mentioning, if you've got these agreements just sitting in the cabinet from 2 years ago, there isn't really anything that we can do as practitioners on those agreements. But certainly when an employer comes around to try to enforce it, then your limitations period would start up on that. With regard to the savings clause, and I don't know if this is in the General Counsel's brief, Tim, that you mentioned on Stericycle, but Deputy General Counsel Orr said yesterday that savings clauses, as you said, Tim, maybe not. One thing I think that the General Counsel is going to be looking at is, where is the savings clause in the document? If you've got some 30-paragraph agreement and it's at the very end, that's probably not the best place to put it. So anyway, I think that's all I have to add on that one. Thanks, Tim and Lance.
Yeah, so I had just a couple of follow-ups, and before we jump to the next topic, since Lance and Pat raised these matters. First, what Pat was talking about, the confidentiality of financial terms of in a severance agreement or in an NLRB severance settlement agreement, a private agreement, a non-board agreement. I would practitioners who are with us every month probably know about this memo. Others might not, and so I will mention an old memo that is still out there. It still provides good guidance. It can be found on the website. The memo is identified by the letters OM, Operations Management, OM, and the number is 0727. So it's a memo from 2007, and it provides guidance to practitioners about what terms can and cannot be included in NLRB non-board settlements. And one of the provisions is what Pat mentioned, and that is it's okay to have a confidentiality provision in a settlement agreement with the NLRB private settlement agreement non-board, so long as it's limited to the financial terms. And so that's just a good tip for practitioners, having that memo on the wall next to your desk is a good idea. So you can refer to it anytime you have an NLRB non-board settlement that's brewing. Two other things I wanted to mention. One, this notion of, and this is in the General Counsel's memo 2305 about how, if you do have those severance agreements over there, and what if you want to just not have to be tossing and turning at night worrying about whether somebody's going to file a charge over those? What can you do about that? And the General Counsel provides guidance on that you can remedy, very likely remedy a previously proffered severance agreement by advising employees that the provisions are null and void. Now, if it was proffered within the statutory period, still that's technically an unfair labor practice that might be out there in the air. But there is something called merit dismissals. And so if somebody did happen to file a charge saying you were proffered this, and notwithstanding the employer has said it's null and void, we have prosecutorial discretion, to dismiss those kinds of cases. So again, look at 2305 and you can get some guidance there. And then I just have to say, since Lance brought it up, and I'm not disagreeing with him, I'm going to throw another lawyer. It depends, and it relates to non-statutory employees. And I would tell you, just look at 2305 and look at what the General Counsel said about a case called Harper Robb Chevrolet. So if you did have a vice president who signed a severance agreement, and there was language in that agreement that may could interfere with employees' statutory rights, you just need to be aware of the board's decision in Parker Robb Chevrolet. It's a little wrinkle, probably not going to come up a lot, but since it's mentioned in the memo, I wanted to mention that also. So, okay, we need to continue marching forward. Our next topic is another really fascinating topic because it involves a really controversial area of the law that relates to captive audience meetings. And captive audience meetings are very common and commonly used by employers during union organizing campaigns. And so just as a starting point, what does this mean? For anybody who doesn't know what a captive audience meeting is, well, it's a meeting where employees are compelled to attend a meeting, and the employer in the course of that meeting is going to talk to employees about their Section 7 rights, is going to talk to employees about why they shouldn't support the union, urge employees to reject union representation. So that's what we're generally talking about when we talk about a captive audience meeting. And what is the law? What is the law under the Act as it pertains to captive audience meetings? Well, it's really, really old law. It's a case from 75 years ago, a Babcock and Wilcox case from the late 40s, where the board said those meetings are not unlawful. It is lawful for an employer to conduct those kinds of meetings. Well, General Counsel Abruzzo disagrees with that decision that the board issued a number of years ago. She thinks it was wrongly decided. She is urging the board in cases that come to her, and that cases that then get litigated and ultimately make their way to the board. She's urging the board to overturn Babcock and Wilcox. And when we're talking about captive audience meetings, you need to know that her position is it kind of can come in two different situations. The first one is the one I described already, a meeting where employees are called together on working time, compelled. It's a mandatory meeting. We're going to talk to you about why you should reject union, but it can also come up in the context of what are called one-on-ones, you know, where the employer comes into an employee's work area and says, you know, on the clock and says, we need to talk about this union thing, and you engage one-on-one with an employee to try to persuade the employee to reject unionism or reject the organizing effort. This could also apply, though, even in a non-union context. So it's important for everybody to know that as well. An employer who calls employees together to try to dissuade them from raising some safety issue that the employer hears is bubbling about, or employees an employer hears are, you know, complaining about overtime or complaining about their pay, and we're gonna quash that. That could invoke this captive audience meeting issue also. What does it not include? It doesn't include employer engaging with employees on the clock about, you know, safety instructions, really anything that doesn't relate to their Section 7, their Section 7 activity. So how do you do it right? You know, at least as far as what the General Counsel would say. Well, how to dispel the unlawful, inherently coercive, threatening nature, again, according to the General Counsel, of these captive audience meetings. Tell employees, assure employees that their attendance is voluntary. And I think for guidance there, you might even look at, it's just barely related, but, you know, kind of look at what, look at an old case called Johnny's Poultry about, you know, assurances that an employer would give an employee in a different context, but just suggest people look at that case. So this issue is before the board in a case called CEMEX, CEMEX. It's a case from the NLRB's region in Phoenix. And so this is a write down CEMEX, because this is a case where you're going to see the board address this issue or not, but it's definitely been presented to the board in the CEMEX case. And then the only other guidance I will give you on this before I hand this off is, and again, another General Counsel memo where you can see her position on captive audience meetings, and it's GC memo 2204, which is from just a little bit more than a year ago, April of 2022, and that again is 2204. So that's all I had on captive audience. So I'm going to throw it to Pat now.
Well, all I'll say for this is it's been a long time coming. That's it.
Okay, Lance.
I guess I could be short too and just point to 8C of the Act. But I may say a little bit more in that, you know, 8C of the Act provides constitutional free speech rights to employers to express their non-threatening, non-coercive, non-promising views to employees. And, you know, I think most employers take the position that if they are communicating in such a way with employees, be it one-on-one or in mandatory meetings, they are towing the line with respect to their obligations under the Act. With all due respect to what I believe Pat might say is the freedom of association rights of employees. You know, I think there's a balance there, and obviously the statute is all well about freedom of association, but there's a reason that 8C is in there, and we have to give it effect, and we also have to interpret the Act in a way that does not create a constitutional problem. And my colleagues feel that infringing upon the right to have these captive audience meetings interferes with that.
I wouldn't expect him to say anything different.
Okay, we'll count that as a rebuttal then. Yeah, and I mean, the only thing I could say is, you know, we don't know what the board's going to do with this. It's the issue's been presented to the board, and in more than one case, and we'll just have to wait and see how that plays out. Okay, shifting gears, going to talk. I think we have enough time to hit a couple more topics here at least, and then have time for questions still. I wanted to spend a few minutes talking about remedies. There have been a couple of recent cases where NLRB remedies has it's been an issue. And before I talk about those new cases, though, I just want to do a reset and remind everybody. No punitive damages under the National Labor Relations Act, no assessing penalties, no treble damages. The statute is a make whole statute. So in the classic case of an employee fired because of protected activity, the remedy is make whole, put that employee back where they would have been, reinstate them, give them back pay, and restore all their terms and conditions back to the status quo. In order to get as much out of the statute as we possibly can, I want to just tell you a little bit about what the General Counsel's view is on ensuring that rights are fully protected, and then just tell you in practice kind of what we're doing in a field office. If you haven't had a case with us recently and you get sent a settlement agreement, it's going to look different than one from a couple of years ago, because we are asking for some other provisions in settlement agreements, pretty standard now. So as a starting point, we are not agreeing to settlement agreements, informal settlement agreements with parties that would be approved by me, the regional director, agreements that include non-admissions clauses, just not doing it. Also not agreeing to remove default language from our settlement agreements. All of our informal settlement agreements are including default language. They don't include non-admissions. If it's an employee who's been discharged, we're asking for 100% back pay. If an employer wants an employee to waive reinstatement, then you're going to have to pay more than 100% back pay in order to secure a waiver of reinstatement. We are also pretty regularly asking for training, a provision where a board agent would conduct training for supervisors and managers about statutory obligations, training for employees, again, conducted by a board agent about statutory rights, letters of apology in cases where there's been an employee discharge. We are asking for and getting regularly settlement agreements that include letters of apology. Know about other kinds of remedies out there, depending on the circumstances of the case, access remedies where maybe a provision in the settlement agreement would provide union access to employees to state their case in a bargaining case where there's been dilatory bargaining. A bargaining schedule might be something that would be included in a settlement agreement. Notice reading, we're asking for that in appropriate cases. And in fact, a case that NLRB attorney litigated for another region, and I was the acting director for a case called Gavilon Grain from more than a year ago. The board granted a notice reading a remedy in that case, and they've done so in other more recent cases also. So some recent board cases that you need to be aware of. The first one is called Thrive, THRYV, and it's found at volume 372, NLRB number 22. It's a case from December of last year. And in that case, the board said that direct or foreseeable pecuniary harms, AKA consequential damages, appropriate in part of traditional make whole relief. So that's something that the board found in Thrive. And so we are seeking consequential damages in all appropriate cases. The other new board case that I wanted to mention is a really recent case, so less than a month ago, a case called Noah's Ark Processors, Noah's Ark, and the volume number is 372. And the case, the slip op is at number 80, 372, number 80. It's from April 20, 23, so April 20th, 2023. And it's a real interesting case because the board, it's an unusual case because the board talks about, hey, here are the kinds of remedies that we would consider in appropriate cases. And they tick off all these remedies. One would be a requirement that in addition to posting a notice, which is standard in board settlements and in judge orders and board orders, also requiring a union or an employer to post a notice or an explanation of statutory rights. Also, reading the notice, reading the explanation of statutory rights, mailing the notice, mailing the explanation of statutory rights, requiring that a supervisor or a high-level manager be present at a notice reading, publication of the notice in a local publication of broad circulation, extending the notice posting period. The traditional NLRB settlement and board remedy is that you post the notice for 60 days. In this Noah's Ark case, the board said the notice should be posted for a year. So this is something that's being done by regions and settlement agreements, and obviously by the board in the Noah's Ark case. Okay, that's my remedy discussion, and I'm throw it to.
Before you hand it off, Tim, we have a question in the chat. One of the attendees wants to know whether or not attorney's fees are a part of remedies regularly awarded.
So if you're talking about board attorney's fees, yeah, I mean, that's something that it's not common, but that is asked for in some extraordinary cases. Yes.
Okay, so we'd hand that off now. I think it's Pat's turn to go first.
Okay, I can certainly applaud the General Counsel and the board's, I would call, aggressiveness in trying to come up with some remedies, because ever since I've been practicing law, Congress has not seemed to be able to get around to doing something to support the National Labor Relations Act in a way that I think should be. But I do just want to say to the union folks out there, these remedies apply to you too. Tim touched on it there just briefly, but keep that in mind. If you're operating a hiring hall or getting involved with a DFR case, you need to be alert and concerned about these remedies as well. So that's all I have. Lance?
Yeah, so, certainly understand the rationale behind Thrive, ensuring that an employee who's been let go, things like, a mortgage payment hasn't been able to be made because they've been out of work, things like that, certainly makes sense. The thing that I'm kind of struggling with when it comes to Noah's Ark is that the board seemed to be talking about extraordinary remedies that could be considered for repeat violations. At least in my experience, I don't know that I'm really seeing that trigger, that threshold being met before seeing some of these. Is there some rationale behind kind of going for the gusto on some of these things, even though this could be like a first time situation for an employer?
Yeah, I mean, I think every case is different. Look at the circumstances of every case. I mean, I think that the starting point is we want to get as broad a remedy as possible and ensure maximum wringing out as much as we possibly can out of the remedies that are available in the statute. But in not exceptional cases, yeah, you know what? It's a settlement agreement, right? We're negotiating with you. We're firm but fair. And so, depending on what the circumstances are in a case, we will hear what your concerns are and can be flexible depending on the circumstances.
Yeah. And I forgot to mention one other thing. I've seen board settlements now requiring the texting and or emailing of notices. I don't think you mentioned that, Tim, but that's another thing I've
Yeah,
seen.
and I mean, that's pretty close to being established law now. The board said a number of years ago that, you have to post the notice in a way that, in the way that you communicate with employees about working conditions. And so if it's very, very common. In fact, I would say it's uncommon if there's not some form of electronic communication with employees about their working conditions. So for sure, notices have to be posted, by email, by Slack, by text messaging, by any number of other, potential electronic communication platforms.
Gentlemen, we have about 10 minutes left. Tim, if you want to just maybe bullet point a couple of the other hot issues you think we're currently percolating, not that we're going to go into many depths, because I've got one question in the chat box, at least give a couple minutes for the attendees to perhaps ask some other questions.
Yeah, I will. I do want to mention just one other big case. And again, it's a Texas case. It's a Region 16 case. And so it's near and dear to us from a geographic standpoint, but it's also a big case. It's gotten a lot of attention in the last few weeks, and it's a brand new case. It's a case from May 1, and it's a case called Lyon Elastomers. Again, a case from right here in Texas, down in your area where you guys in the Houston area are, 372 NLRB number 83, May 1. And the board overturned a case from just a couple of years ago, a case called General Motors. And this is a case that involves employer responses to employee outbursts, or cases where employees may do something that causes them to lose their protection under the statute. And the board in Lyon Elastomers, I would say, restored old precedent in reversing General Motors, returned to setting specific standards. So when you're looking at a case where an employer is in the office with an employee, and the employee engages in an outburst, talking about working conditions and says something inappropriate. Atlantic Steel is a case from 1979 that the board overturned in General Motors. Well, that's been restored. So that's old law, more than 40 years old. So that's what would govern that kind of employee outburst. If you're talking about picket line misconduct, there's another old case, almost 40 years old, a case called Clear Pine Moldings from the early mid 80s. That governs that misconduct in that setting. And then there's a case called Pier 60 from 2015 that governs misconduct that maybe goes on social media. And so the board in Lyon Elastomers has restored all of those standards, rejected the board's decision in General Motors that only the right line, the motive standard should apply, and again restored some old law. And so you want to know about the Lyon Elastomers case. It's going to be on review. It's going to go to the Fifth Circuit. I think that Thrive case that we already talked about also on review to the Fifth Circuit. So know that. But if you're looking at cases involving whether employees may have lost protection, you want to know about the Lyon Elastomers case. And then I guess quick,
Lance or Pat, either you have anything you want to jump in on any of those subjects?
Well, Lyon Elastomers, I want to give a shout out to my good friends and client, the United Steelworkers. That's a plant over in the Beaumont area that's organized, and I actually had some involvement in the case that Tim is referring to, but not on the board case, on a court case, but involving the same employee. And I'll just leave it at that. Lance?
I would, I certainly understand that the board may feel that the specific standards that they've drawn out over the years are better apt at addressing the misconduct that arises in these different situations. I do think that when you look at some of the misconduct that has passed muster in front of the board, it oftentimes runs awry of other federal statutes like Title VII, harassing statements made. And, I think the hard part for employers and perhaps the hard part for the labor board is, balancing its statutory obligations to interpret and enforce the act, but do so in the context of all the other statutes. And then, of course, employers are left to try to figure out, what do we do? We have diversity plans in place where, we feel very strongly that, for example, racial epithets should not be used in the workplace, but some of these standards would see, as applied, would seem to implicate that might be okay when exercising Section 7 conduct. So I think, it puts employers kind of betwixt and between in a lot of these cases. I don't know if right line is the solution, but I do know that there's got to be a better way of interpreting the act in the context of all the other federal laws that are there. And I know that's a hard job for the board because they're not called upon to interpret those other laws necessarily.
We have one question in the chat. Well, it's actually more a position statement, but I'm going to try to characterize it as a question that has to do with captive audience speeches. The way I would pose the question is, if a captive audience speech is truly captive and mandatory, how do you see the analysis going for the balancing of the perhaps conflicting rights of freedom of speech versus freedom of association? And I'll throw it out to whoever wants to jump in.
I'll take it. So when we're talking about employers exercising their freedom of speech rights, it's exercising those rights under the lens of the NLRB looking at our statements in determining whether or not they are indeed, we are indeed constitutionally privileged to make those statements. In other words, are there threats, are there promises, is there coercion involved? And if there isn't, then we have a constitutional privilege to make those. And most employers' position would be that the board should not be attempting to regulate that non-coercive speech. Whereas in the context of the employer requiring an employee to attend a captive audience meeting, the employee vis-a-vis the employer does not have a constitutional right to freedom of association. They have that with respect to their rights vis-a-vis the government, not their rights vis-a-vis an employer. And so we believe that, if you are working for us and we decide that we want to have a meeting and you're being paid, we have the privilege to communicate with you in those kinds of meetings. There's obviously a lot of debate over that. But we're not a state actor subject to the Constitution in the same way that a government actor is. So I think that that's the distinction, at least from the employer's perspective.
And if I could,
the time, but I'll let each of you, Tim and Pat, have your response.
Okay. Yeah, I just real quickly, I would just say, I'm just gonna echo what the General Counsel's articulated position is on this, and that is that compelling the employee to be there is inherently coercive and inherently threatening, and that's the position that she's taken. And as I said earlier, we're just gonna have to wait and see what the board says.
And I'll just, for the sake of time saving, agree with the General Counsel on that one.
I want to let me finish this response so that for people who are seeking SHRM credit. Tim, Pat, Lance, I want to thank you so much for taking time out of your busy schedule to participate today. As I said at the outset, traditional labor law has always been my first love. And I'm really excited that we had such large participation in this program. I thank you for your insightful perspectives on the issues and highlighting the hot issues there. There are tons of others. I know, Tim, we talked a little bit yesterday about there's probably going to be going back and revisiting handbook rules again. So, and then the other thing I'll mention for those who may be on the call, but this is to state the obvious, anyone who's been around labor law. The National Labor Relations Act applies to employers, not just those who have unions representing a majority of employees in an appropriate unit, but also to what we would generically call non-unionized employers. So the law is out there. And while I was actively doing labor law, I had several unfair labor practice cases filed against non-unionized employers. So these principles and issues are alive and well for all employers in the country. Again, thank you for your attendance today. I appreciate your time. If you have any input, Mickey Brock put his email address in the chat box. Please feel free to send them your thoughts and comments. Otherwise, I will thank everyone and have a great rest of the afternoon.
I wanted to make a couple of points, if I may. I thought it's a fantastic panel. And so I just want to thank all of you for doing a great job. Be sure to check your Texas State Bar number if you want to get MCLE credits and SHRM information. We're going to have a program in September 21st, where we're going to have an outstanding guest speaker of Rick Levy, who's the president of Texas AFL and CIO. You'll be hearing more about that. And if you're interested in any kind of leadership role or getting more involved in LERA, let me know. And finally, I just want to thank everyone for taking the time to be with us today. I just thought it was a great program and great attendance. So thanks, everyone. And we hope to see you in September.
Thank you.